Hello, everybody. I'm Ron Yank, and I'm moderating the first of two panels that deal with specific proposals put forth by our little group. To read the whole uh, set of proposals at once, go to the online edition of the California Law Review that's in your materials. I want to kick off because we've got a lot of ground to cover by introducing our panel. There's Will Atchison. Will, wave at the audience. Will founded a company called EIRS. He's the founder and executive director. And that group has put on seminars nationwide for about 40 years in the area of both firefighter, public relations, and police. But of course, we're here mostly to discuss police. He's had police leaders, police lawyers, and management lawyers. And as a result of his publication and all these seminars, I know of no one who has more expertise on what's going on in police labor relations on a nationwide basis than Will. He's represented dozens of police unions in the western states, so that right now, even though he's stationed in Portland, he comes on down to Los Angeles and represents the deputy sheriff's union there. Will's a graduate of Georgetown University Law Center. He's authored several books on public sector labor relations, including The Rights of Law Enforcement Officers, which by now is in its 7th edition. John Hochman graduated from a small little law school down the peninsula. I'm a Cal man, called Stanford Law School. And he's the founding partner of what's called the Rennie Public Law Group that represents management in a myriad of various health benefits, pensions, but for our purposes, arbitrations, fact-finding, and negotiations. He's negotiated at least dozens of MOUs. For those who aren't necessarily into what MOUs is, it's the same functional equivalent of a CBA collective bargaining agreement. MOU is Memorandum of Understanding. John's the author of the Rudder Law Group's California Practice Guide, dealing with public sector matters. A key point for our purposes, he recently served as special counsel to the Fresno Commission on Police Reform that produced about 73 recommendations that were adopted nearly unanimously by the 40-member commission. And Subramanian is the managing director of Policy Link. And you heard that organization described or mentioned earlier by Nancy Skinner as one of the progressive groups with whom she works in pushing through progressive legislation when it comes to police reform. Policy Links advances community safety and justice through campaigns and programs to the paradigm away from surveillance and punishment toward healing and community investment. He also directs Policy Link Legal and so on. A major thing for our purposes is that he served as the executive director of the San Francisco Blue Ribbon on Transparency, Accountability, and Fairness in Law Enforcement. One project that Anand is working on and I think is heading up is a commission established by the city of Oakland to do what I call rethinking the police or reimagining the police. So, Ron Yank. All right, so I practice union side labor law, mostly for firefighters and police for 40 years, retired for 3 years. After that, Jerry Brown decided to ask me to switch sides and represent management on the other side of the table from unions, again, including two of my ex-clients. Yes, appropriate waivers were signed by everybody. So that's my story, and I'm sticking with it. All right, I'm going to turn to what I call fishbowl bargaining, and I don't think I mean it in a derogative nature, but what it means is public access to bargaining for a main or regular MOU. That is a contract that covers wages, hours, benefits, how you sign up for a shift, retirement, healthcare. Anyhow, you get the drift, the whole 9 yards. And that wasn't one of our little group's recommendations, but I think it has to be addressed, especially since it was addressed in our very first panel this morning. So, Anand, I gather that you're kind of in favor of fishbowl bargaining. Could you tell us why?
Absolutely. Hi, everyone, and thank you so much for having me here for this important conversation. As Ron mentioned, I served as the executive director of what was called the Blue Ribbon Panel on Transparency, Accountability, and Fairness in Law Enforcement, which was an investigation in 2015-2016 of the San Francisco Police Department for institutionalized bias in the wake of horrific racist and homophobic texts that had taken place and been discovered as a result of a federal investigation into an unrelated matter. We issued a report in 2016 where too many of the findings related to the undue influence that the San Francisco Police Officers Association had over the department and its policies. And so, for example, it had undue influence over departmental culture, but also abused its labor privileges to block, weaken, or delay common sense reform. And so fast forward a year or so later, I, along with about 30 to 40 other organizations, formed what was called the No Justice, No Deal Coalition that was explicitly...
I get all that, but what's that have to do with fishbowl bargaining? Why do we need fishbowl bargaining to advance reform or progressive causes?
Yeah, I'm getting to that. So part of our argument there was that the police contract negotiations were handled like every other public sector negotiation, employee negotiations were handled, and that we had to differentiate law enforcement, police associations when it came to police contract negotiations. And the reasons why are because there is a public safety implication to every term potentially that goes into these contracts. And no one is looking at those implications and weighing those implications vis-a-vis the wages, benefits, and working conditions that, of course, the police associations representatives are looking at. And then on the city side, we found that really they were too concerned with the bottom line, the fiscal implications. And so for one reason, I think we need to make them public so that the folks who are most impacted by oppressive policing, Black and brown people typically, have the opportunity to review the terms that are on the table and can weigh in on the public safety implications, on the implications related to how it affects their lives. And the second thing I'll say, and I'll close with that, is we know we have seen over the past 8 months that...
Say one thing to back up. I agree with the impulse towards transparency generally in negotiations, because as a management negotiator, all we have when we go into the table is our logic and our wits, whereas we don't have any power. And obviously there are political forces, et cetera, that we're up against. And so transparency generally, I think, supports us. I'm pretty strongly opposed to fishbowl bargaining, however, at the point prior to impasse, I should say, because after impasse, I think fishbowl makes all the sense in the world. But here's the problem. As a management negotiator and a guy who frankly has convinced a lot of police unions to agree to a lot of police reform, you have to have a really candid dialogue at the table. And of course, that's the history of labor bargaining generally. And when it comes particularly to police reform, I'm going to use a term that cops will bristle at, but I'm going to say it. You have to have a sharing of fears at a bargaining table. You have to, when you talk about reform, cops are notoriously, they don't like their cheese moved to begin with. It's just a thing. They're very status quo oriented. And there's always the concern that these reforms are somehow going to adversely affect them. And so from my perspective, what you have to do when you're negotiating or discussing, I should say, not negotiating, reform issues is go through the whole process where you show that these are not things that are going to undercut the personal safety of the police officer involved. They may even enhance the personal safety of the police officer involved, or whatever other concern they might have. So I find that, if you have that kind of fishbowl bargaining, one, you're less likely, as you say, to make a deal, at least outside of impasse. I'd say the other problem with it is, honestly, labor negotiators, if you're good, it's about trying to understand the other guy's perspective and then move them, right? And so the difficulty is, if you put me on and I've got to just give my spiel, spiel 1, spiel 2, spiel 3, and they'll give their spiel 1, 2, 3, and believe me, they're going to be good at coming up with whatever that choreography is as well. It's not going to get us anywhere. So only one of two things are going to happen. I'm going to go out for drinks with their negotiator. I'm going to figure it out. That might be one thing. Or the other is that, we're just not going to reach an agreement, and we're only going to inflame and antagonize each other. And so, I understand that there are a lot of problems with police unions, and I agree with much of what Anand said. But, I just don't think that fishbowl bargaining is the answer.
Okay, Will, can you chime in? And I'd love it if you gave a specific example as to how it can undercut bargaining moving forward.
Sure. And first of all, thanks for the opportunity to address everybody. It's my pleasure. So I think when we're talking about fishbowl bargaining, we really have to break it down into its component pieces. There's the part of bargaining that occurs before the first bargaining session, and that's in the development of proposals. Then there's actual bargaining itself. Are those bargaining sessions going to be open to the public? And then lastly, there's the point after impasse is reached or an agreement is reached. To what extent should or can the public be involved in the ratification process? And you really do have to break all those three apart, because they're not the same thing and they don't involve the same considerations. There's very little fishbowl bargaining that goes on in the public sector. When you have a city or a county or a state, they don't bargain contracts in open session. You're not going to see the city of San Francisco, for example, sitting down with Xfinity and negotiating its rate agreement in public. You just simply don't see that. And the reason is that the involvement of the public in the bargaining process, frankly, gets in the way of reaching an agreement. And I'll talk about how that happens in just a moment. So let's take the first part of that, the involvement of the public in the development of the proposals. Presumably,
Will, that's our next topic.
Oh, okay. Okay, well, then I think we're going to cover the other two aspects of it as well, Ron.
We are. So how about...
Okay, I won't say anything else then.
Well, no, point out how a union might get into trouble with something that the rank and file put forth as a proposal were there fishbowl bargaining.
Sure, and this would be what I've described as part 2 of the process when you're bargaining. And I've done this. I have bargained with the media and the public presence, so I have some experience with it. Everybody needs to understand what the collective bargaining process looks like, how it plays out in real life. You typically start with both sides coming in with wholesale proposals to change the contract. And then there's attention given on a proposal by proposal basis. You go through the proposals, you advocate for them, you ask questions about them and the like. And then you get to a consolidation stage later on in the process. In the consolidation stage, you will package together various proposals and put them together. Some of them will be proposals that you want something, and some of them will be proposals where you're making concessions to the other side. I've been in the situation, bargaining in the public, where the bargaining has been live streamed, where members of the labor organization that I represent are watching the live stream and are simultaneously sending us tweets or some form of DMing and telling us, why in the world are you selling us down the river? Because they've seen the concession that is part of the package without having the opportunity to have the context of the concession. It makes it very, very difficult to engage in the sort of meaningful change that you need to have at the bargaining table if you are deprived of the ability to explain why you are doing so to the union membership in advance. And I would assume that John would have very much the same concerns with members of his city councils watching negotiations unfold.
All right, so Anna, I gave these two characters the last word on that subject, but I want to move to another thing that maybe you might find more attractive, which is our group proposed that there be a public hearing before management even constructs its proposals. So let's say the community thinks the police department budget is too bloated, the money should instead go to mental health or libraries. This would be the chance to weigh in, both in writing, because not everybody can show up at a public meeting, and at a public meeting, and tell the city, we think you ought to have this and that and the other thing. And by the way, go wipe out provisions 15, 22, and 78 in the police MOU. Why isn't that more meaningful public input than watching them bargain? And do you like this pre-management constructs its proposals hearing? Do you even like that idea?
I do like the idea, and I don't think it needs to be an either or. I think it's a great idea that should happen in addition to fishbowl bargaining. I think that the challenge of isolating public input to that pre-stage is that it's far more challenging to understand where the public or the folks who are most impacted by the contract or policing in general would prioritize vis-a-vis the terms that the other side's coming to at the table, and they don't know those terms yet, for example. So if there's a priority on the front end of we want these terms out from the last contract, for example, well, what are they bargaining for? What are they accepting from the other side? And is that worth it to the public? So I think it needs to be an ongoing process. And I think that the challenge with doing it at the back end, per Will's point, is that typically we're all in a really tight budget cycle. There's a lot of pressure at the end to get this contract done before the budget has to be approved. And without understanding what the terms are that are on the table from the earliest perspective, and having the public weigh in on what the priorities are for this contract, there's too much pressure to just rubber stamp something at the very end.
Okay, John, the community shows up and they're all in favor of a 10% pay cut across the board so that the extra money can go to mental health and libraries. Or, maybe that's not outlandish enough. They want to get rid of, they want to make all police officers at-will employees. This may be a little tough for you, but how are your city councils, boards of supervisors going to react to such pressure? Are they all going to cave? Are they all going to stand up to it? What?
Well, you know, you have to take a step back here and look at what the polling says, because you know, the legislative folks, and this came out, I think Senator Skinner said it very well, actually. You know, there are actually, in reality, your hypo's not quite right, because in reality, there are two themes going on. One is that by and large, people, including people of color, under the most recent Gallup poll, shows African Americans and whites are actually similar in this regard, want policing. The difference is, you know, obviously, is they want policing that is appropriate to their communities, you know, and so there's a big difference. But I think there are these two strains going on. People want policing on the one hand, and they want reform on the other, and they ought to be able, in a sense, to have both, or at least have public safety. Maybe I shouldn't use the word policing, because I think that kind of assumes something. But the answer is that politicians will make their choices. I think, as Senator Skinner said, there's, you know, the unions don't lack for sway with elected officials, even very progressive elected officials. So, you know, my job, I always say this, you know, my job is more to get alignment, what I call organizational alignment, on my side than anything else. So I think short answer is having that input on the front end is a terrific idea. It helps me as a negotiator, because then it's not just management that's saying this. This is you can draw from the stories and the will of the public, and I can use those stories and I can use that energy. It's very, very, very helpful to me. You know, and you know, if it goes a little too far, the bargaining process is probably going to bring it back.
Will, I brutally cut you off when you were about to talk about hearings before the city constructs its opening proposals. Can you now speak to having this kind of hearing on the very, very front end?
Sure. I mean, I would, representing police unions, love to have the opportunity to have 10 or 20 or 30 police officers come and address John's client and tell them what his proposal should be. I think that would be wonderful.
They do that already, Will, but they just do it behind closed doors.
They do it quietly. More seriously, I want to tell you that while this sounds good, and I don't oppose it, there have to be very tight ground rules on how it is going to happen. Because when you say the public, we're sounding like this is going to be some sort of Socratic debate and exchange. And I'm from Portland, and I'm here to tell you that it's not always that way. The first day of bargaining for the Portland Police Association's contract this year was January 13th. On January 12th, Antifa came to my office, broke 12 windows, and completely destroyed one wall of the building with anti-police union graffiti. That night, in the middle of the night, they came to my partner's home. They shone strobe lights in his windows, banged on his front door, and set off noisemakers, instructing him that he should not represent the police in bargaining the next day. We are not unique. That has happened. That sort of thing has happened to lawyers representing police unions in Sacramento, in Kansas City, in Lincoln, all over the country. And those same people who did that will show up at this meeting to inform John as to their wishes. And they will behave in the same fashion. If you're going to take this sort of input, if you are a governmental employer, you have to be very careful about how that meeting is going to be handled and the security and contingency plans for that meeting.
One of the things I want the audience to think about, no one needs to particularly comment it on, speak to it now, is not the whole big issue of transparency somehow a statement that we are not satisfied with our representative government, that we can't trust city councils, boards and supervisors, et cetera, to somehow have their collective fingers on the pulse of the citizenry, et cetera. And look, that's just a passing kind of thought. Right now, most public entities allow for public hearings after there's a tentative agreement. And I think John might have, well, no, I think it was you, Annan, said it's a long process and then they're in a hurry to get done. Does anybody think that input on the back end before actual legislative ratification is meaningful or helpful? John shaking your head no. I've never seen a contract rejected after there was a tentative agreement. Has anybody on this panel seen a public entity vote down an MOU?
I have, but it's police management. San Francisco has voted down police management, but Anand has been involved, I think, a little bit in San Francisco, and there was a recent example. It didn't get voted down, but where input at the end actually did bend the curve. And so I wouldn't throw it out in the sense that I think it's valuable. Let me just say, I think that there are a couple of things that need to happen. One is you have to have two hearings, not one. You have to have a sunshine period for the stuff coming out, so you're not so rushed at the end. That a mandatory, let's say, 30 days. You have to have an analysis of the MOU that's done by a neutral-ish party, so that people can digest it in bullet point form, because nobody can read an MOU. And so I think it can have an impact, but I think fundamentally, you really are in a position at that point where you're I'm not very good at football analogies, but it's you're on the other side, on the other side's goal line. It's very tough to turn it around. But I would say, I mean, San Francisco is an example where I think some significant change was made.
Well, I'll speak to that real quick. I think that certainly in the context of that 2018 contract, our demand as a coalition was that the Board of Supervisors reject any agreement that didn't include our demand, which was that the Police Officers Association waive their meet and confer and interest arbitration rights where it came to policies that were a direct result of implementation of 272 policy recommendations that were part of a collaborative review that the San Francisco Police Department participated in with the federal DOJ, Department of Justice. But we expected actually that there would be an agreement and that we'd need to try to advocate for the Board of Supervisors to reject it. But actually, it turned out that agreement was not made, I think partly because Department of Human Resources did put that demand on the table in the 10th hour, say. And so it did go to arbitration.
And then they actually took it to interest arbitration. And that's where they lost, is the arbitrator. Okay. Here's one. I don't know that anybody on this panel supports it or cares. At least in state service and maybe in sub-public entities, they require sunshining of both sides' opening proposals. So these are the opening proposals, and they're to be made public, and the public, I guess, can write letters to the editor about how outrageous the union's demands are, or contact their city council person about what a wimpy proposal management's is. Does anybody support the continuing sunshining of opening proposals?
I support it, but let me just say, in preparation for this session, I spent a fair amount of time talking to negotiators who do education, which is where this is most prominent. Under EERA, there's both pre and after, or what Will would say is number 1 and number 3 in his list. And the difficulty has been really in the way it has ended up working out, which is, number 1, all they do now in the educational setting is they identify the sections of the MOU that they're going to seek to renegotiate. They don't say a thing about like how they're going to renegotiate them, or they say something very general like we seek to have equitable wages, things like that. And obviously, I don't think any of that is terribly meaningful. I would also say, I mean, it could have a paradoxical effect if you wanted to be more specific, because as the labor negotiator, and Ron was sort of implying this issue earlier, if you give me, a bunch of things I know I can't get agreement on, I'm going to fail, at least in your eyes. And so I just have to tell you on a human level, I don't like the spot it puts me in to go out there and say we're going to go after the following 50 changes, and come back with 2. I guess one other caveat, and I think this is maybe we should make this point explicitly up front. So a lot of people, when we're talking about this issue, are thinking of use of force changes and things like that. So use of force is not in the mandatory scope of bargaining. And there is no reason why use of force should be bargained at a main MOU bargaining table. And I strongly advocate against doing that. I also strongly advocate against having MOUs that tie management's hands during the life of the MOU on what we think of now as essentially the police reform agenda. It includes use of force, but there are other things as well. And I strongly oppose zipper clauses that tie and this is one of your recommendations, your group's recommendations, is to not have zipper clauses that tie your hands during the life of the MOU. And here's why. You don't want piecemeal bargaining over police reform. What you want is to have a considered program of police reform that you bring to the table as a unit, and you're not trading it off against money. I mean, seriously, are we going to say, I'll give you an extra % if you stop shooting at cars? That doesn't make any sense. It makes sense to treat these processes separately and to understand that most of these issues, like whether you shoot at cars, are not within the scope of bargaining. And employers need to get serious about drawing the line on that issue.
Okay, we got a little bit off of sunshining, opening proposals, but let me pick up on this thing about bargaining on use of force. So John says, and he's got at least one case behind him, if not more, that bargaining on use of force is it's not required by an employer. Is there any aspect to a change of a use of force policy that should be bargained, or do you think even a change in, I don't know, shooting at cars should be bargainable?
Well, I think just from a standpoint of getting a complete picture, I think it's really valuable for the employer to hear what employees feel about changes like that. So, for example, I had an employer that was considering a policy of not shooting at cars and was ready to implement that policy. Came to the union and said, what do you think? And our answer was, what if a car is driving down a sidewalk picking off pedestrians, which, as we all know, happens. And the employer ended up changing its policy because of that to something that took that sort of exception into account. And so I think the input of employees on those issues, even if they're not strictly negotiable, I think that input is incredibly valuable to employers and to the public and should be considered by them. I agree with John that use of force standards are not what are known as mandatorily negotiable. But there may be safety implications to use of force policies, for example, where employees might have the right to bargain over the effects of those policies. That's a distinction that California's Public Employment Relations Board has drawn and is drawn all over the country. But you don't end up seeing, because use of force policies are not negotiable, You don't see them in police labor agreements. I can't think of a police labor agreement in the country that has as one of its clauses a provision as to when a police officer can or cannot use force and the degree of force that the officer is allowed to use. You just don't see that happening. On the issue of open proposals, I'm all for it. Put the opening proposals out there. I just want to make sure that from the standpoint of representing unions, that before those proposals are publicized, we have the opportunity to go to our membership and to explain what the proposals are. Because frequently, you start with higher numbers and greater benefits than you necessarily expect to get. That's just part of the bargaining process and compromise. And Ron, if I could finish with one completely separate point. There's really no relationship that has ever been proven between any provision in a police labor agreement and police misconduct. Before we start talking about upending the bargaining process, upending it in a way that I think most of us agree is going to be destructive of the ability to reach an agreement, before we do that, don't we need that evidence in hand? Don't we need to make sure that from an empirical standpoint, we're making the right choices? It's not there now.
And any thoughts on Will's last point? What is there in the San Francisco POA MOU, because you're most familiar with that, I assume, or Oakland, that contributes to police misconduct, police brutality?
Mm-hmm. Well, I mean, just on that last point, I think, let's just think about the premise of this entire event. We are here because our system is not working. And the approach to this conversation has been, what is the impact of changes on our current approach? Well, the current approach isn't working. So I feel like we need to start from there and, and get above the weeds a bit and think about, to Will's last point, the overall and overarching implications of not making drastic changes, which is a part of the problem. I am all for a transparent empirical evaluation of policing and how cost effective it is, how effective it is at preventing violence and crime. I think that's a great idea, and I would love to sit down with everyone who holds that data and do that evaluation in a transparent way. And so I think that's a great concept, and to make some decisions and conclusions based on that. Just to answer the question that was on the table, I think that absolutely, like, opening positions made public is partly what I was saying earlier, in that we need to know what both sides are coming to the table with from the get, so that we can have a good analysis going into the negotiations. And I feel like to the point about the use of force policies, I absolutely concur with the recommendation from the paper related to implementing the policy, even as you're negotiating around the effects of it. And I think that should apply to every policy that is outside the scope of, that is within the scope of managerial decisions. And so even if it's not the case in San Francisco, jumping back to your last question, even if it's not the case in the San Francisco MOU or the Oakland MOU, which I don't think there's anything directly related to misconduct or discipline there, a little bit attenuated from like actual policy and process, but around the country, clearly terms related to misconduct process, disciplinary hearings, et cetera, is well within the scope of many contracts. So I think that absolutely is.
For all you audience members, our next panel on accountability is going to be discussing some of those MOU provisions that Anna has referred to. For example, pulling an incident out of a file if the officer has been clean for a year. So Will and John, you both John kind of leaned against fishbowl bargaining, and Will seem more strongly opposed. But we've got a management group that does want input from the union, and not just, kind of dropping by or asking the union president to drop by HR or the chief's office, and they say, we're willing to bargain about use of force issues, this one particular issue, shooting at moving cars. But if we reach an impasse, we're just going to go ahead and impose it. But by all means, we want to go ahead and bargain. And so you've got that kind of gracious offer from an employer. Do you have the same objection to fishbowl bargaining on a use of force issue should management permissively decide to do it? Will.
Okay, I was waiting for John. He's been going first. Actually, I don't. I would love to be in a fishbowl on a single issue on use of force policies, because the evidence, there is a fair amount of actual evidence out there about use of force policies, and in particular about police use of force, both deadly force and non-deadly force, and use of force based upon race or socioeconomic status and the like. Evidence that's not really talked about a lot. I would love to be having that discussion in a fishbowl. I would love to be talking about the incredibly split-second decisions that we force our police officers to make with respect to the use of force, and the training that goes into officers exercising the discretion that we force them to exercise under the law. I would love to go in and to talk about the impact of use of force incidents on police officers. The fact that close to 50% of police officers today are suffering from diagnosable PTSD because of what's been going on over the course of the last. I mean, I'd love to have those sorts of discussions, and not as a vehicle so much of convincing management, but as a way to talk to the public, because police unions, at least the ones I represent, don't have the ability to have that conversation with the public because they simply don't have the resources to do it. And frequently, some members of the public aren't even interested in the conversation.
John, what's your take on fishbowl on use of force when your client has said, yeah, let's hear what they have to say?
So let me just say, it's probably unfashionable to say that what Will just said has a little bit of an influence on me. I would have said, had I not just listened to Will, I'm really glad that he went first, that again, the sharing of the fears is my concern, right? That, you do want folks to be, first of all, and I need to say, when I say these things are outside of scope, I'm simply saying they're not a mandatory subject to bargaining. I encourage what we often refer to as consultation, as long as we're free to walk away from the table, we're not caught up in impasse procedures, and we're free to implement. Because I do think, and Will's absolutely right, that police officers are out there and they're going to say, well, what about this situation? What about that situation? And they're going to be right on some of those things. And it this is, you hate to say that bargaining works, but bargaining sort of works in that regard. And so consultation works in that way. I actually think, having heard Will, that he's right. When you sit in these conversations, and I'm a strong advocate of police reform, you do hear things about safety, about the safety of the public, his example is a very good one. And it does help you refine the proposals in ways that are important for the protection of the public, or perhaps for protection of police officers, which is important too. So you know what? I changed my vote. I'm in favor of it.
Right.
Wait a minute. I convinced John of something.
Yeah. Don't get a swollen head. It's not going to happen again.
Okay.
So listen, I had assumed all along you'd be in favor of fishbowl bargaining on use of force, and I have any thoughts on what either of these two guys just had to say?
Not really. I think yes, I am in favor of it. And I think that, again, I'll just go back to my first point, which is that the Police Officers Association representatives are looking out for the interests of police officers, including the safety implications of the use of force policy for officers. The city is typically looking at, like sort of the legality of it without a direct connection to folks who are directly impacted, families of folks who have been affected by police violence, and making that negotiation transparent allows for an opportunity for directly impacted folks to participate in a direct way, which I think is critical.
All right. So amongst our little group's proposals is that personnel records of police officers, and by the way, audience, when we say police officers, that includes deputy sheriffs. So in California, you've got police departments and sheriff's departments, and we're throwing it all under the rubric of police. So we've proposed that personnel records of every officer, any officer, be made public as to any discipline imposed, any arbitration or civil service hearing results, and internal affairs results. So let me give you a classic example. Citizen X says that the officer swore at him for some reason. Lots of departments don't have cameras still to this day. Let's imagine it's one who doesn't. There's no camera, no other witnesses. It's one-on-one. And in the police industry, if it's one-on-one, unless there's some kind of outstanding evidence, it's going to be found not sustained. So we have proposed that even not sustained matters get made public. So Anna and I assume you're in favor of this. Is that a fair statement?
Absolutely. I mean, we were, as Senator Skinner shared, we were a sponsor of SB 1421, which I think doesn't go far enough, and absolutely support that. I have a whole analysis around it that I don't know if we have time for, but I would love to, if we do, come back.
Alas, we don't.
Okay.
But essentially, this proposal is anything to do with discipline. John, other than this might be quite a burden in terms of personnel costs for producing a bunch of records for a bunch of officers. And by the way, folks, that's no laughing matter. FOIA requests cost a department like Oakland upwards of $100,000 a year. No one I know is opposing it, but this would be one more burden. So John, what do you think of all you have to prosecute allegedly dirty officers? What do you think?
Well, look, by and large, first of all, let me just say, SB 1421 was one of the best things that's happened from my perspective in this field in a very, very, very long time, and I look forward to it being extended. I don't know the details of SB 16, but I think Senator Skinner made a very important point, which is I have a lot of concern, not from. First of all, Ron, you're absolutely right about cost, but I think, given the stakes here, they're very significant costs, but I don't think it should play in the equation, notwithstanding the fact that it's very significant costs. And by the way, I mean, I worked with my clients on complying with 1421, and it was, a huge burden, but I think it's more than worth it. And I don't have a problem with extending it either. I do have a concern if you start revealing records of folks who've been exonerated. And honestly, this is less about my being a management lawyer and more about my just general sense of fairness, number one. And number two, I am concerned. I feel like cops shouldn't, and this is where Anand and I probably part company a little bit. I don't feel like cops should be treated worse than other public employees, and other public employees have some privacy rights, et cetera. I can understand it in the setting of use of force and things like that, where there's a compelling public interest. But I have a lot of trouble when you're dealing with disciplinary issues where there isn't that kind of compelling public interest.
Will, what's your thought on this opening of personnel files, including not sustains?
I think there's a backdrop we have to consider, and the backdrop is not talked about as much as it should. There's a crisis facing law enforcement in this country right now, but not the crisis that some people might identify. And the crisis is one of recruitment and retention. People do not want to become police officers today, and they do not want to remain police officers. If we looked at the situation a year ago, we were seeing articles being written in professional police journals that described this as the worst recruitment and retention crisis, their words, that we have ever faced. And in particular, we have been unable to attract the sorts of people that we really do want to attract to policing. People who have college educations, people of color, women, groups that we have been targeting for recruiting for a long time. Those are the people who are in particular voting with their feet and voting away from police careers. I have seen studies done from the middle of 2020 in which as much as 90% of existing police officers would not recommend the career of a police officer to their children. And really, today, in the environment in which we are with respect to police, what sane young woman or man in their early 20s who's college educated would choose to become a police officer? So that's the backdrop. Now, against that backdrop, actually, I don't have any problem with discipline, the imposition of discipline, and the justification for the imposition of discipline being released to the public. It's a balance, right? You have to draw that balance somewhere. Police officers not going to like it, but the public, I think, has a right to know about that. But as to not sustain charges, you have to understand that people deliberately file false complaints against police officers. It happens all the time. I could give you 100 cases that I've handled over the course of my career where that's exactly what has been done, and it has been done deliberately. If that sort of and those complaints run the gamut. They run the gamut from, he arrested me without probable cause to she stole $10,000 I had in cash in the back of my car, to allegations of sexual misconduct. You make that all public, and what you're going to do is destroy the subject of those complaints, that police officer, with their community. And think of being in that police officer's family and reading about that in the newspaper. I'm also opposed to the release of the underlying records associated with imposed discipline. So, for example, take a case of sexual harassment where it has been investigated, the charge has been sustained, it's 2 employees who have been involved, and discipline has been imposed on one of the 2 employees. Do we really need to see the transcripts of the disciplinary interviews in which incredibly intimate details about the allegations are being discussed? I don't think so. There is a balance, and I would come down on the side of sustained disciplinary findings and the imposition of discipline being disclosable to the public.
Okay, for our audience, we didn't go as far as transcripts, et cetera. It would have been Officer Dokes was found guilty of sexual harassment and lost his arbitration case.
Okay. If I could just very quickly weigh in on part of this. So, I don't know that it's unfair to treat police officers differently than other public sector employees. I think that is the point. One of the main takeaways I'd like to present as part of my participation here is that police officers, as someone named in one of the questions, have the power of life and death to legally end someone's life. But more than that, they have the power to end folks' lives or severely influence other people's lives in other ways by arresting them, by criminalizing them, And so even if we're not talking about one instance of a non-sustained complaint, if there's a pattern of complaints, even if they're not sustained, I think at a minimum, that should be a public record.
All right. We've got time at least for one more question that somebody typed up. I can't read it, but I'll give you the gist of it, which is that collective bargaining agreements, and this circles back to a question I asked you, Annan, all over the country protect dirty cops. And Sean, what kind of provisions that you know of protect officers who ought to be fired?
Well, I think the biggest issue, and Anna made this point too, the biggest issue that is in collective bargaining agreements, although only in very vague form, is the disciplinary process. And there are, by the way, provisions in a lot of MOUs in California, at least, about things coming out of files after 6 months and things like that, which I think are very bad. And clearly need to go, and that do make it harder to discipline. But I would tell you that to me, and this is one where Ron, you're an arbitrator, so I'm going to tread a little lightly in how I say this.
Come on, I retired again. This is going to stick. Go ahead.
I do not think, and I do not think that police discipline should be decided by arbitrators, period. And here's why. Without, and I know arbitrators take great offense at this, and Barry, I respect Barry, for example, and you hugely, but the difficulty is, it goes to what, I don't know if any of you remember Justice Otto Counsel on the California Supreme Court, who I clerked for. And Otto Counsel coined the phrase, the crocodile in the bathtub. And he talked very candidly, this is a California Supreme Court justice, about how in the Prop 8 case, the fact that if they were going to throw out Prop 8, that the politics were going to kill them, basically. And ultimately, Justice Grodin was one of the victims of that public backlash, right? And so there is a crocodile in the bathtub, and I'm not suggesting arbitrators are weighing this versus that too much, but on any given case. But I think that you should have, the administrative office of the Corps, OAH, which is state hearing officers, or some other body like that doesn't have to work again, doesn't have to get hired again, right? That's not part of the equation deciding police discipline cases. I think we should take it out of the hands of arbitrators. I mean, Judge Henderson talked about this, and I was involved a little bit in Oakland way back in the day, as Ron, and Oakland would lose a huge number of arbitration cases. Now, I don't want to criticize Oakland. There's a lot to be said about how well you prepare a case. It depends on how it comes out and all of that. I get that. But, what you have to remember about this is the arbitration phase is a major protection that for police officers in a very secretive kind of way.
Okay, Will, I'm going to give you the last word. We've run out of time. You get the last word about throw out arbitrators and replace them, I guess, with administrative law judges.
Or judges or whatever, call it what you will.
Sponsored, created by the state.
Well, arbitration is a tried and true system in labor relations, been around with us for 80 years, 90 years. My experience is that police unions appeal discipline to arbitration far less than 5% of the time, which means 95% of the time they don't even file a challenge. And the evidence is pretty clear on a national level that police unions win about 50% of the cases they have in arbitration. That is the same number of cases or percentage of cases that other types of unions win. With arbitration, you get people who do labor relations for a living and understand this, understand the whole process. So I disagree with most of what John said, but I would agree with one thing. I would love it unless there were particularly intimate facts associated with an arbitration case. I would love to have arbitration hearings in the public. I would love for the public to be able to understand what it is led to particularly some of these very high profile arbitration decisions that we've seen.
All right, we're going to have to leave it there. For those interested in arbitration, the next panel discusses our little group's recommendations vis-a-vis arbitration, what can be changed, what should be changed, etc. So I thank my panel, and we're going to take a break until 3, and that's when the final panel on police accountability, aka arbitrations, etc., comes on. So panel, thanks, and see everybody back here at 3 o'clock.